everyone. Well, I hope spring has sprung where you are. And if that happens to be New York City, HR departments are going to have to take a good look at their drug screening program. On May 10th, a new city council rule went into effect that essentially makes pre-employment marijuana screening an unlawful discriminatory practice. That means you need to take a look at your drug panel and take out marijuana if it's there. Now, of course, there are exceptions to this rule, as with many others. Those who don't have to follow this are law enforcement, public safety, childcare, healthcare, commercial driver's license holders, and even people working with federal government where there might be contracts that require drug screening. Otherwise, everybody else needs to stop right away. Now, if you're a client of EBI and you need help or you have questions about that, email us at compliance@ebiinc.com and we'll help you out. On the flip side of all this, there are soaring numbers when it comes to unemployment and more people claiming unemployment benefits than ever before. And you might not realize this, but there are certain rules you have to follow when you're claiming unemployment benefits. One of them is you have to prove that you are unemployed through no fault of your own. With COVID-19, that's pretty easy to do. But the other one is that if you get an acceptable job offer or you're called back from a furlough, you have to accept. If you refuse the job, you can no longer claim your benefits. Now, with COVID-19, obviously there are issues. You may have an elderly family member and you can't risk going out into the world and bringing COVID home. Or maybe you have kids and there's no school, there's no camp, there's no daycare, so how can you possibly get back out there, yet you still need the benefits? So Texas has stepped in and actually changed those rules. Now in Texas, you can legally turn down a job or return from furlough and still get your benefits as long as it's for a COVID-19 reason. But there is, on the flip side, a benefit to the employers. If you say no to the job, they don't have to hold it for you. The only people that are protected in that manner are those who are on paid sick or family leave. Now, everybody wants to get back to work, and there's a judge in Ohio who is doing everything he possibly can to get a trial going for a guy charged with child endangerment. And right before he called for jury selection, the defendant and his attorney started claiming they had COVID-19 symptoms. The judge says you're coming in anyway. During jury selection, the defendant fell to the desk and needed an ambulance and went to the hospital. Both he and the attorney were tested. Turns out no one had COVID-19, but the doctor said, hey, quarantine for 6 days. The judge was not having any of that, and he called them back to try again. That's when the attorney went to the Supreme Court of Ohio to say, hey, we got to stop this. His reasons are pretty interesting. He's saying he can't defend his client properly if they're forced to sit 6 feet apart at a desk and cover their faces. They can't confer. He also can't go to a witness and present a document, and he really can't judge what's going on in the witness box, if the jury box rather, if everyone's wearing a mask. So that is tough. We understand it, it makes sense, and it actually translates out of the courtroom into the work world. We've got to all take a hard look at our work environments before you call your employees back and check for those little details, those little stumbling blocks, and make sure you have a plan. And we're going to try to help you through it. Be sure to watch our blog and check out all of our COVID-19 information at ebiinc.com. Have a great week, everybody. We'll see you next time.